Hello, everyone. Welcome to another Talking Feds one-on-one. So we are reaching the point in New York versus Trump where the judge will instruct the jury on the law to apply after the jury hears closing arguments. And in this case in particular, there's been from the time of charging a couple tricky, latent legal issues that could really affect the jury's deliberation, and moreover, it could really matter how the judge specifically instructs the jury in what is a somewhat complicated case where misdemeanors were charged with the possibility of becoming felonies. So this is the perfect time to talk about it, and the perfect person to talk about it. Judge Shira Ann Shinlin, who served on the Southern District of New York, the federal bench in Manhattan for 22 years, is now of counsel at Boies Schiller Flexner and has a robust mediation, litigation, otherwise neutral practice. She's gracious enough to join us today. Thanks so much, Your Honor, for being here.
My pleasure.
All right, let me just lay out we've read about it, but I think for a lot of people, they haven't really fastened on to the core tricky legal issue at the heart of the case. So the charge, as people know, I think is not hush money, not electoral offense, but falsifying business records. So we know that there are a series of vouchers and checks and invoices that are allegedly false because they say, in essence, that Michael Cohen was being paid for legal services when in fact he was being reimbursed for having paid off Stormy Daniels. Let me just first, do I have that right so far? And that's a misdemeanor offense to just do that. And let's stick with the misdemeanor for a second. What do you have to do to commit a misdemeanor and not be elevated to a felony? I think that would be 175.05.
That's exactly right. That's a misdemeanor, which says a person is guilty of falsifying business records in the second degree when, with an intent to defraud, he makes or causes, that's an important word, makes or causes a false entry in the business records of an enterprise. And that's what happened here. The business records of the Trump organization say that this was payment for legal fees. Now, the question is, was Trump aware of that?
Okay, so let's start there. So we have an entry that's false.
Right.
All right, but you said two more things, it sounds like. One, Trump has to make or cause that false entry, and he has to do it with intent to defraud.
That's right.
Yeah. So I'm sure you've had similar statutes about causing. What's it mean to cause it?
He is the head of the Trump organization. It's known, approves everything. So he has to agree that that's the way it's going to be set up. And according to the testimony, he knew exactly how this was going to be done. Cohen allegedly tells him, this is how we figured out to do it. He says, just get it done. That's fine. And he understands and approves that the records will show a payment of legal fees rather than a reimbursement of hush money payments.
All right, but let me ask, and I have trepidation to interrupt a judge and ask questions, but it's my job here. Because I think the evidence could be taken that for him to have concurred, all right, get it done, as opposed to have ordered. Does that matter? Is that like a fact question for the jury that on which guilt turns, whether he says, whether he sort of does a check mark and signs off as opposed to saying, you go do this?
No, I think that it does not matter. I think it squarely puts him in the same category as the accountant who does it, the person who suggested it. It doesn't matter. They're all in it. They all committed this misdemeanor by knowingly, willfully, with an intent to defraud, change the business record from what it should have been to what it appears to be.
All right. So if you're the big shot and you say, okay, now you've caused it, it sounds like. And I'm sorry.
I think it also, the word is makes or causes. I think it's really both. By approving it, and he's the head honcho there, he understands it. He does it knowingly. There is an intent to defraud. I think there's no question on the misdemeanor part.
All right. Well, but let me ask you. But there is that one last point with intent to defraud. How does that apply here, and what would it mean not to have an intent to defraud when you make a false record?
Well, here he's doing this in order to protect from the public information they would otherwise be entitled to. After all, this is a week or two before an election, and he knows after the tape had come out that was so damaging that if there was more about sexual encounters, that it may affect the voters really negatively. So he wants that suppressed, and he knows that there's a scheme to get it suppressed. That's why he says, just get it done. He's aware of it. So the defrauding is defrauding the electorate in having the information they would otherwise have. This should have been public information, as was the tape, but it wasn't.
Got it. Although we know that it's not against the law per se to pay hush money, but still he's intending to defraud. You said because he's intending to leave the public with a false impression.
Well, he's intending to impact a federal election, an important federal election, the election for the presidency. So it's not a crime to pay hush money to keep a story quiet. If he was sort of not a public figure, not running for president, there's no reason he can't pay somebody off. But here, it seems to be pretty clear that at least one of the motives of keeping this story out of the public eye was so the voters wouldn't know about it.
And that counts in your mind as intent to defraud.
It does.
Yeah. And we'll get back to that, at least one of the motives. Okay. So, and that's how we get to the misdemeanor, which is the core of the offense, and is sort of I think a lot of people think that's pretty straightforward at this point. Okay. Now, how does New York get that misdemeanor, charge it so that it becomes a felony?
So we talked about 175.05, but to become a felony, there's another statute, 175.10.10, and that makes the business records, the falsification of business records, a felony if it's done with the intent to commit another crime and conceal the commission thereof. So that's the actual language of 175.10. Was there an intent here to commit another crime and conceal the commission of that crime?
Okay, and let's unpack that then. So you've got an intent to commit another crime or to aid or conceal the commission thereof. That sounds like you don't have to commit the other crime. You just have to have an intent to do it. Is that right?
That's exactly right. It's exactly right. You do not have to charge that crime. You don't have to prove that crime beyond a reasonable doubt. What the jury would simply have to find is there was an intent. We intend to commit this other crime, and that's why we're falsifying the business records.
Okay, but we're slicing the salami pretty thin now, right? Because the intent to commit another crime, they do have to find beyond a reasonable doubt. It's just the intent,
no.
yeah.
No, the jury has to find intent as part of proving 175.10 that makes it a felony, but they don't have to find beyond a reasonable doubt that they intended to commit a specific crime.
A specific. So now maybe even thinner. Do they have to find beyond a reasonable doubt that there was an intent to commit another crime, whatever it is?
Well, that's right. I think you phrase it better than I do. I think they do have to find beyond a reasonable doubt that there was an intent to commit another crime, but they don't have to find beyond a reasonable doubt that there was an intent to commit a particular crime.
Right.
Still, they're going to have to understand what is the DA's case, the people's case, as to what they're talking about. What is this other crime that they intended to commit?
Yeah, so let's play that out, please. And we reached the kind of puzzling point that from way back when, the DA has declined to specify. He's just given a kind of menu of options. So how is that working here? And maybe we can go also to your practical experience, 22 years on the bench. Are we starting to get at a point where jurors are going to have trouble kind of applying all this? But um, I just asked a compound question. Object, sustain. I'm sorry, Your Honor. So let's just start with here. So there's got to be some crime, but the jurors don't have to agree on what that crime is.
Well, it's like a predicate act in cases I have had, which is RICO violations, have many predicate acts. They don't have to necessarily agree on any one, but they have to agree there was one.
That there was one.
I know that sounds like a fine distinction. So I do think here the judge is going to have to explain the potential crimes that they intended to commit. I think the DA in summation is going to have to list the crimes that they intended to commit. But then they can leave it to the jury to decide if they all agree that at least one or more of those crimes, this defendant intended to commit one or more of those. So I don't think they're limited, but I think somebody has to explain to them what they are. They don't come to this trial knowing about the New York State
the criminal code, right?
Right, the criminal code or the tax fraud law or the federal Election Campaign Act or anything else. They don't know about these things. So clearly, when the DA sums up and explains this case and explains this felony charge, they're going to have to say that it was done with the intent to commit another crime. And here are the other crimes that the people have proved they intended to commit. Then the jury doesn't have to, all 12 don't have to agree on which one, but they have to agree that at least one, if not more, they intended to commit.
All right. And there have been 3 proffered so far. So 1 to 4, jurors 1 to 4 could think it's crime 1, jurors 5 to 8.
I believe so.
And now we are getting into, you've sat on the Second Circuit, I know, by designation. And so I think we are maybe getting into tricky appellate territory. Do you think that if that's exactly what happens, and he charges them that way, withdrawn, as they say to the judges. Something that Judge Merchan can do would be to, Justice Merchan, excuse me, would be to have a special verdict form, yeah? And say, specify what the crime is. But of course, that would make it harder for the DA because they would have to agree. Do you think there's appellate exposure here if the judge says, as we've just outlined, as long as you choose one, it's okay? In particular, since it's not clear that all 3 of the charges are independently kosher, we have a federal election violation. How does that work for the state crime? We have a tax fraud, and then we have a state election violation. You're the judge now. What are you thinking about how you want safely but fairly to charge them? That we're at the nub of a tough problem, huh?
Right. It is a great question and a difficult question. What I don't know is whether there's any law that the judge can follow from the highest court of the state of New York, the New York Court of Appeals, or even from the appellate division, the intermediate appellate court, that has charged this falsification business records as a felony with the intent to commit another crime. So is there precedent that says all 12 have to agree as to what that other crime was? Or is there precedent that says they don't all have to agree on which crime, but they all have to agree there was an intent to commit another crime? So I don't know. I have not researched whether there's precedent or whether poor Judge Merchan is having to do this in a way for the first time. And he himself is going to have to take a chance. And he's going to have to decide whether to charge that you all have to agree that there was an intent to commit another crime, but you don't have to agree on which crime it was, so long as you all agree that there was an intent to commit another crime. So I suspect If I were in that position as a case of first impression, that's what we lawyers call it, the first time, I think I would say you all have to agree that there was an intent to commit another crime, but you don't have to all agree on which it was, as long as all 12 of you find an intent to commit another crime.
Yeah. And I actually think there's soft precedent in that regard, but something that comes home to me that would be worrisome were I on the bench is one, if any of the three charges that are floating around is an appellate court later finds to have been infirm for whatever reason, that it doesn't apply there. Now we're in a pickle.
That's right. That's right. Because it might have been that there were 4 jurors for each of the 3, 4 times 3 being 12. If one of them can't be the definition of, quote, another crime, then you have a real problem with this verdict. So let me back up a little and say that I agree there has to be a special verdict sheet.
Okay. And explain, please, for a second what a special verdict is.
Yes, of course, because not every one of your listeners has seen one and done one. But it lays out for the jury how to make their verdict. So it says, do you find that Trump violated the statute that forbids falsification of business records? Then you have a line that says yes and a line that says no, and you check it off. Then it's, do you find that Trump did this with intent to commit another crime? And you check off yes or no. And then you say, if you answered yes to question 2, which crime or crimes do you find that he intended to commit? And then you give in the instruction. That does not need to be unanimous as long as all 12 of you agree that there was an intent to commit another crime, which you just did by checking yes. But you want to know for appellate review what the breakdown was. Now, it may be you get lucky and all 12 says the other crime was whatever we decide as we continue to talk here, or you have 6 feeling one way and 6 feeling another way, and nobody takes the third one. That might be helpful too. So we don't know, I don't know yet what the judge's charge says. Have we seen that publicly, by the way? Is the charge out there yet? I don't know.
No, and we're going to, so it's funny, we're thinking, okay, we have to summation and then the jury has to get the case. The charge is really important here, and the charge conference where the lawyers are going to argue in front of the judge, that's going to be contentious and time-consuming and maybe take papers. I'm just mentioning this because the scheduling of the case is tricky because, this Thursday, so there no court on Wednesday. He wanted to, but the jurors couldn't do it. So Monday, Tuesday, if they get the case Thursday, there's an immediate 4-day break, which I think you would not want to have a jury do. But it's going to take some time. There's the possibility of a defense case. I don't see it a big one, and then there's I think summations take a day. But this is a point that people aren't considering. They're gonna be haggling over the instructions in front of the judge for hours.
Let me explain to your listeners how I handled preparing a charge. So I would have submissions first, written submissions from each side as to what they would like me to charge. After reviewing those submissions, I would draft my charge and give them a copy of the draft. Then I would listen to them say to me what was wrong with my draft. So I would give them a draft, and then they would say, well, no, Judge, page 32, we would think it should be this way or that way. And I would make changes going with one side or the other side on their views. And then I'd have a final charge. And I would say, your objections are on the record. You preserved them. You've objected to the way I'm going to charge it, but this is the way I'm going to charge it. Once I have it in final, this is what I did. I made 18 copies, and each juror got a physical copy of my charge to take into the jury room. So I read the charge in open court, but then said, you're each going to have a copy of this because it may be helpful to you to go over it as you deliberate. I don't know if Judge Mershon will do that.
Some judges don't. It's interesting. But now we have the 2 lawyers in the room who are, all right, includes, and that could be really important, right?
But it's very helpful for the jurors to have the charge because they don't have to ask a question. Judge, can you reread the charge, on whatever the topic, on reasonable doubt? But instead of having to do that, which we used to have to do years ago, they have the charge on reasonable doubt, and they can read it themselves in the jury room. So I gave them a copy of the charge, and that's the way the charge was developed. But it took a lot of time.
Yeah, that's the point, right? This process of fighting back and forth, and your draft and your final, and so if we're contemplating what the schedule is this week, and when that could really be a chunk that people haven't taken account of.
Do we know that he hasn't done some of that already? Are we in the know? Has he given them a draft? Do you know?
I don't know about the draft, but we haven't had the conference.
No, I know we haven't had a charge conference. That I would know. But I don't know behind the scenes whether they're all working on the charge. Have they submitted proposed charges? Because as I said, the way I did it, I took proposed charges from both sides. Then I did what I wanted. I wrote my draft. Then I let them comment. Then I improved my draft. But then I told them it was final, and they had preserved their objections. And that's very important, that if lawyers think there's something wrong in a charge, they have to preserve their objection for appellate review. So the charge is a big part of this case.
He's got to maybe he's a very methodical, a lot legal-driven judge. He'll take some time. There are a couple big cases, one Supreme Court case, one Court of Appeal case that, he'll really be studying.
Well, no, I think he already has. I think you're not giving him credit. I bet he's got a draft charge in the works. I suspect he worked on it all weekend. I think he's got something ready, and I think I suspect they've submitted proposed charges to him. I don't know that, but I think they would have been working. The legal beagles back at the shop, not the trial lawyers in the courtroom, have been working on charges all along. They've probably submitted it to him. He's probably drafted it. I think he's ahead of where you think he is. They haven't had the charge conference, but I bet they've been working on this.
I'm sure you're right. All I meant is when the final things come in, he may, and I don't know if he'll issue any kind of written opinions about the different, core issues.
No.
Yeah.
No, I think the charge speaks for itself. That's his resolution. Now the charge conference, at least in my courtroom, was always on the record. So when they have the charge conference, they will be saying, but we asked for this, but we oppose that. And I rule this and I rule that. So I don't think you'll get a written opinion on that. I've never heard of such a thing, but the charge conference is on the record, which is his rulings, plus the charge itself is his final ruling.
Yes. And just thinking about when that happens in a week where tomorrow we tape on Sunday, there's still evidence to present and closing arguments. At some point it's going to be potential.
Well, let me add one more thing for your listeners. You really can't sum up without knowing the charge.
100, right?
The truth is, I was sure that my lawyers knew exactly what I was going to charge, and I told them they were allowed to quote from my charge because it wasn't final. So they couldn't sum up before the charge conference. It's not after the summations. It must be before. And they're allowed to put on the screen, here's what the judge will tell you.
Your Honor will tell you the law, but right.
No, more than that. No, I let them say, the judge will charge you that these are the elements of the crime. The judge will charge you that, and I let them quote from it because it was in final. So they were allowed to put on the screen what I'm about to read because they know I'm going to read it word for word.
Got it. All right. So we have this core issue we always had of how do you get the misdemeanor up to felony level, what the judge will do as far as special verdict of the candidate offenses. Well, one final question there. Do you think this is just our both speculating in a different role, but should the DA, to date, they have fastidiously declined to bottom line on their candidate crime to elevate to felony. Do you think at this point the DA should just choose one and argue it or leave it open-ended this way?
I do think they have to choose one, although they can present all three. But I thought I read, you can correct me if I'm wrong, that one of the prosecutors, Colangelo, had actually said to the court that they were either had decided or were leaning toward the charging that the violation of the New York election law was going to be the other crime. And that crime prohibits conspiring to promote or prevent the election of any person to a public office by unlawful means. Now, that one is extremely tricky because then you have to define what's the unlawful means? So it's pretty straightforward to say conspires, that's him with Cohen or him with Cohen and Weisselberg, to promote the election of any person to a public office. That's easy. But by unlawful means we have to have yet another crime in our minds. Or close to a crime, what are the unlawful means? And there's several choices for that.
That's exactly right. And I agree with you that Colangelo has as much as said that's where they're leaning, because he actually told the court early on, conspiracy has always been a part of this case. We haven't charged conspiracy, but it's a part of the case, and that's what he was referring to. All right, so we have quite a...
so should we tell them what the unlawful means are?
Yeah.
Well, so
so we need this. We do need this extra element, right? Because we've noted if it were just hush money payout, that wouldn't be. So that's right. So we get successive levels of complexity.
It's very complex, and it's very hard, I think, for the average person to understand all this. I think the average person sees this trial as him paying off porn stars, and that's it. And so he's a very sleazy, corrupt guy. But this complexity of trying to figure out the intent to commit another crime, and then if it's the New York election law, you have to do it by unlawful means. This hasn't been discussed very much by any of us until this final week, and then we're all going to be talking about it.
So I think we have laid out this very complex web of issues in the elevation to felony. Let me ask a couple follow-ups. I can imagine a strategic choice by Trump to say, I want a lesser included offense. I want them charged on the misdemeanors that they can find that only, because given these legal complexities, maybe he's convicted of the misdemeanors, and maybe this is where the strategy would lie. He declares that a victory if he walks on the felonies. Can the defendant do that? Say, I want them to separately judge whether I did the misdemeanors before they get to the felony?
Well, now you're asking me a challenging question only because I was a former federal judge, not a state court judge. So I think the answer is yes, he can ask for the lesser included offense charge. But you tell me if you're an expert in New York law.
My best guess is yes also. I also was a federal prosecutor, although I spent a summer at the Manhattan DA's office when it was at quite a period in the mid 80s in New York.
Anyway, it's good that the two of us agree that indeed the judge will charge at somebody's request the lesser included offense.
Yeah, and that person would be Trump. I mean,
I think so.
It really would invite. I always, as a prosecutor, did not want a lesser included offense because it really invites the jury in any halfway difficult case to split the baby. And I think,
but I will ask you this in return: if he asks for it, is there any reason Mershon wouldn't do it? I think he would do it.
I think the way the crime is defined, Your Honor, is it kind of has to be, because it truly is a lesser included offense. It's embedded in there.
So this is good. If we both agree, that's a good sign.
All right. Couple quick questions. You referred to mixed motive. Do you have a sense? I know, again, you're a federal judge, not state judge, but I think this might be a general legal principle. Let's say the jury is persuaded that he had dual motives for trying to cover this up. He wanted, and the evidence is very strong that he wants to just get past the election, and that's part of what's going on, is to hoodwink the people, as you say. But he also wants to protect Melania and, shield her from and whether there's a dollop of that is unclear, but let's say the jury decides it. Does that count if you have mixed motives? Is it clear?
To me, it is. I think that's fine. As long as you have the motive to defraud the voters, it doesn't matter that you have a second motive to protect your family. So I don't have any problem with that.
That would be my instinct too. Okay, so I think that's the main cluster. I know you've been thinking about this, and from your special vantage point of having been on the bench, any other sort of important and contentious legal issues or practical challenges for Mayor Chun as you think about the upcoming charge conference?
Yeah, well, I'm going to answer that, I promise, but I want to go back to unlawful means because you didn't let me speculate as to what the unlawful means would be. So one possibility is on the unlawful means is the violation of the Federal Elections Campaign Act. But there's a question about that. That's the one that would be careful about sort of contributions in kind, which is sort of what happened here. Would that have to have been reported?
Political contributions in
Yeah,
kind.
of course, political contributions. But the problem with that is that's a federal offense. And so it's unclear whether the state statute that uses the phrase unlawful means can be a violation of a federal law. And that's the one that was the most likely candidate for the unlawful means, but it may not work. And if they decide that is the unlawful means, that's another fascinating appellate issue, whether a federal offense can be the unlawful means, or does it have to be a state statute? So what are the state statutes? We're left with tax fraud, which is a very strange one because this is a tax fraud that would give the government more money than it's due because
Right.
it would be paying the government as if there were 360,000. I think I have my math wrong there.
Yeah, no, they double.
Yeah.
Well, they double the 180. You're right. No, you're right, and then add
Okay,
60.
good. So they'd be taxing on 360 when there was no 360.
Right.
So the government would be getting more money than less money. So can that be tax fraud? So that has a problem. If you don't defraud the government, is it a fraud at all? I understand it's a business record falsification, but I'm not sure it's a tax fraud. So that's another possible unlawful means. The only other one, and I can't really work this through in my mind, is more violations of the 17505, the falsification of business records. Other falsifications is the unlawful means, but that sounds circular to me, and I don't know that that works. So I am struggling with the unlawful means if that's their choice of the underlying crime that they intended to commit. That's why they may go with the other choices, which we didn't really talk about, which would be the tax fraud, but we just said why it has problems, or would be, don't think it can be the federal crime. I don't think
Well, and because are they? And I'm sorry I didn't lay enough groundwork. I fear some people and listeners their head might be spinning. So I just want.
That's okay. Our head is spinning too.
Too. But I just want to stick a pin in this and say, so in order to get from misdemeanor to felony, it's in the commission or intent of another crime, and the candidates there are a state election law violation. That's the one that specifies. That seems like maybe what they're doing, but that does specify, as Her Honor says, the unlawful means. So now we're figuring out where is that extra element, or is it bootstrapping or federal election law? And the argument is New York does go and choose in its elections federal electors, but does that mean a federal law violation governs, or this tax point where you commit fraud by giving the federal government an extra $180,000. And so this is sort of head spinning. And this is one point where from the start, I think people have been saying 2 lawyers on the jury, unusual. Have you ever been chosen on a jury, Your Honor?
No, I haven't. But I've had lawyers sit on juries where I tried the case as a judge. I've had many lawyers sit on juries. But
I haven't either. But so that could be an outsized influence people think about, yeah.
Maybe not, because I don't think, if I remember the voir dire part of this, the jury selection, I don't think they were criminal lawyers, either as prosecutors or defense lawyers. I think they both had civil practices. And in fairness, when I talk to lawyers I know who have only civil practice, they're as lost as the rest of the population. They don't understand the intricacies of criminal
Even
law.
the parsing of unlawful means and such. Maybe you're okay. So anyway, I think we have a welter of legal, practical, and kind of collaborative in jury issues. It's very, very hard to draw the Venn diagram.
It is very
it's hard
hard,
enough.
and I'm sure I'm sure we're going to see diagrams.
Yes.
I predict that in the summations, you're going to see a diagram of how the DA gets there through each of these steps to make it clear to the jury. Now, one more thing, I want to answer your question. You said, were there other legal issues, as if this isn't bad enough and hard enough for the judge? I do think there are a couple other legal issues. And here's my short list of them. One, is he going to give a missing witness charge? Because everybody's saying, where was Weisselberg? Why didn't the people call Weisselberg? I can't imagine the defense won't mention that and say, it's their burden, they failed, and we're entitled to a missing witness charge. I wonder if he'll give that. They're not favored in federal court any longer, but I don't know again about the state courts. They may give that. Another charge I think is going to...
Let me just stop you. If they do, it would be that he would instruct the jury not to draw any inference one way or another from something like that.
That's the current way of giving the charge in federal court, but the older way was you may infer that.
Oh, I see. I didn't realize that. Yeah.
Yeah. That changed in the years, but when I was a judge, it became what you just said, that you may not draw any inference in one way or another, but then why give it? So we'll see. I don't know what the charge would be, but you asked me what issues the judge might face. Another one, not hard for the judge, but hard for the jury to understand, is a charge he will give, which is called falsus in uno, where he will explain to the jury that you can believe a part of a person's testimony, even if you believe another part was not true, or you can believe all of it, or you can believe none of it. And I think juries take that charge very seriously, and it's very helpful to the prosecution when they say that even if you think he lied about some things, that doesn't mean he necessarily lied about everything. So he's going to give, I'm sure it's an interesting charge. The other thing I think that may come up is knowing and willful. This phrase, knowing and willful, is found in the Federal Elections Campaign Act. So if that's the unlawful means, then it has to be done knowingly and willfully. And does anybody think that Trump knew the text of the Federal Elections Campaign Act, or even if he didn't know the text, did he know what would violate it? Did he have any clue that paying off a porn star to keep it from the public violated that act? I doubt it.
That extra willful implies, right, a sort of specific intent.
Yes, I don't think that could be done. So those are some of the other issues
this is invaluable. Let me ask a final practical question, because you've been with let's say that, obviously it could go on forever. There could be what's called an Allen charge where the jury can't agree and the judge says go back. But it seems to me, Judge, that what you've laid out is even if there's relative unanimity, we've got a bit of a time-consuming process. I'm just sort of thinking now about how long you would expect deliberations to go. And obviously it depends on where they're going, but you've laid out what would be pretty short, pretty long as we're sitting there, and the hours and days are ticking off.
Yeah. So as one lecturer that I heard recently said, I can talk about history and I can talk about the present, but I don't have a crystal ball for the future.
Yeah, right.
So I don't really know, but I think if it was only the misdemeanor charge, they'd be done the same day they were charged. But with all the complexities that we just discussed, I think there'll be some real wrangling in that jury room, and I would certainly expect it to go into a second day. But I could easily be proved wrong on that particular prediction because I don't have a crystal ball.
Of course. But as a practical matter, I guess judges think maybe not so much when the case is done as the next one. But for advocates, when the jury is out, the question is, at what point do you start to think, they're really deadlocked or they're really thinking about it? And to me, this is a sufficiently complex case that point doesn't come until the third day. It's roughly speaking. In other words,
I think that's right. But the old saying is the longer they're out, the better for the defense. So we'll see if it really goes to a third, fourth, or fifth day. The tea leaves tell you it's going to be a hung jury. Now, if you talk to 5 sophisticated people, there's a pretty heavy percentage vote for hung jury. So I'll ask a friend who does criminal law, do you think it'll be a conviction, a hung jury, or an acquittal? Well, almost nobody thinks it'll be an acquittal. So I'm getting 60-40 conviction versus hung jury, but I've also gotten 40-60 conviction versus hung jury. So I think those are the two big options that we're going to hear. Is it going to be a conviction or a hung jury? I don't think acquittal is in the cards.
But you've said you think that the misdemeanors are, so I assume the acquittal position is, I mean, the hung jury position is on the felony, yes?
Yes, exactly. Exactly.
Wow. Well, this will all be playing out. Such a great opportunity to be able to talk to you. I feel like, you one goes to court and one hopes for 5-10 minutes from a thoughtful, indulgent judge, and you've given us so much time. I feel like guilty as an advocate, but it's very gracious of you. Thank you, and I hope we can maybe check in with you as the legal issues perhaps extend over the next week or two.
Thank you.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.